call to order the Senate Judiciary Committee this morning. The committee's first order of business, having closed the hearing on SCR 1602, is to now open working SCR 1602. And if we could have the reviser just briefly give us the bill brief, that would be appreciated. I see we have Mr. Thompson from the reviser's office. Do we have Matt from the reviser's office as well?
Thank you, Madam Chair. This is Jason with the reviser's office. I don't see Matt yet. He may join us later, but I'd be happy to give you the bill brief if you'd like.
That'd be great. Thank you. Go ahead, Jason.
Okay, thank you, Madam Chair. As you recall, Senate Concurrent Resolution 1602 would amend the Bill of Rights of the Constitution of the State of Kansas by adding a new section regarding the regulation of abortion. The new section would state that nothing in the state constitution requires the government to fund abortion and does not create or secure a right to abortion. It would also provide that the people of Kansas, through their elected state legislators, may pass laws regarding abortion. Such laws would remain subject to the United States Constitution's protections of an individual's right to abortion. As with all concurrent resolutions, proposing amendments to the Constitution must be adopted by a 2/3 vote in each chamber in order to be presented to the general electorate for approval. And if it is adopted by that majority in both chambers, it would call for a special election to be held in conjunction with the primary election on August 2nd of 2022.
Thank you, Mr. Thompson. Does the committee have any questions for the reviser? Yes, Senator Corson.
I had a question about, in the explanatory statement, about the use of the word affirm. My understanding, in the way that I believe that it's commonly used in court proceedings and otherwise, and by judges and in opinions and cited, is that the word affirm implies that something already exists, that we are affirming something that is the current law, we are affirming something that is already in place, we're affirming a decision of a lower court. My understanding of this amendment is that it would actually change the Kansas Constitution. So in the first sentence of the explanatory statement on lines 32 and 33, it says the value in both amendment would affirm there is no Kansas constitutional right. I believe that what we would be doing would be eliminating a right that the Kansas Supreme Court has found in the Constitution. So could you explain to me the use of the word affirm? And I just want to make sure that that is the proper word that we should be using there to eliminate confusion. Because again, I just think affirm implies that something is already existing. This would be changing.
Mr. Thompson?
Thank you, Madam Chair. Jason Thompson with the reviser's office. The Senator is correct that affirm does have a legal meaning. In this case, I'm not sure that same legal meaning is intended. This is an explanatory statement that goes on the ballot, and there is some policy choice that is involved in the choosing of these words. So he presents a valid argument about the legal meaning of affirm and about whether this is a change of the current law, which I believe you discussed the other day. And so that word choice is definitely a policy that the committee can consider and change if they feel is necessary.
Thank you, Mr. Thompson. Does the committee have any other questions for the reviser? Seeing none, we will then turn to debating SCR 1602. Are there any comments from the committee? Yes, Senator Pyle.
Thank you, Madam Chair. I do have an amendment. I don't know whether the appropriate time that I want to offer that is that now or.
That would be fine, yes.
So if the assistant could pass that out so everyone could see it, please.
Assistant will go ahead and pass that out. Thank you. While the written copy of the amendment is being passed out, do you want to explain your amendment?
The amendment is pretty simple. And it basically changes the date from August primary of 22, which is basically a special election then, to allow not only partisan voters come in, but independent voters to come in and vote. And my amendment would move up the date to November this fall, to the general election in November. And let me give a little bit of reasoning for this. I know there's going to be some angst on the part of people, but I would like you to remember, if you could, some of you were not on this committee last year, but when we had the hearing a year ago on the bill, very similar, I presented the fact that there needed to be special election language and that it possibly should have to be on a special election, or not on a special election, but a general election, but I refrained from offering my language then. And the bill was passed out, I supported it, it went to the floor, and on the floor there was a pretty vehement argument between a couple senators. One was the carrier of the bill, the other was, I think, was a longtime legislator. And as the arguments went on, it became clear that the Appellate Amendment was necessary. And it went on with a voice vote, and it went on unanimously. And the certain groups that were supportive of that amendment at the time praised that. But praise wasn't what I got when I was talking about it in committee and I left this committee. So today I expect the same, here I am trying to amend something. And as to the reasons why, now that we know last year there was the necessity to put an amendment on, we had 4 reps in the House that would not vote for that amendment. I don't believe any of them returned. But one of those reps had portion in my district, would not vote for it unless it was on a general election ballot. I would ask you, each of you, to consider the calendar of events here. November this fall is a general election. And pass or fail, there will be consequences. If it passes, next year, when we come into session, we'll be working on probably some regulatory language concerning maybe clinic licensure, dismemberment abortion, things that got struck down basically with the court's order. If we don't change the date, and you wait until August 22, we will not be working on those things. More dismemberment abortions will take place. In fact, to me, it runs contrary to the language of value them both, delaying this until August of 22. When we have the opportunity to put this before the voters this November. I listened in to the committee the other day. I did not hear either proponents or opponents discuss the calendar issue. I did have some technical difficulties, as I explained to the chair toward the last 20 minutes. I couldn't get what was going on at the last 20 minutes. I don't know, we lost it or something, but so I can't speak to that. But I know during the time that I did listen in, I did not hear anything as to the calendar. My question is, why wait? I don't understand, unless there are political motivations to put this on a primary ballot. Completely understand that. But again, the whole idea is, let me just say this. Had the court ordered opposite of what it ordered, think about that. Would the opponents be the proponents? Would the proponents be the opponents of this kind of language? If it had been stated by the court that there is no right to abortion and eliminated it, Would we be here discussing trying to put this in the legislature's hands from the opponent's side of purview? I find it interesting that, you know, depending on how the court ordered, either way, I do think this is a good policy to put this into the policy-making hands of the legislators. And so I think if you value them both, we ought to move this up to November, get a vote on it in November, and go from there. If it fails, we'll be back here next January doing this very same thing, and we can put it on the August primary and have two shots. Why would you not want two bites at the apple if you, I don't think it'll fail. I think the Kansas voters will pass this overwhelmingly, and I say that because moral outrage is the greatest motivating force in politics. We know that. We saw that with the marriage amendment in 2005. Kansans overwhelmingly supported that amendment.
Thank you, Senator.
So we have a whole session, Madam Chair, in between those dates. And so I'm offering this amendment because I believe I'm very passionate about this life issue. I do value them both. And with that, Madam Chair, I'll stand for questions on the amendment.
Thank you, Senator Pyle. Didn't mean to interrupt. Does any member have a question for Senator Pyle? And I want to clear up, just for those of you listening online, to participate in a committee meeting, committee members must be physically present in the committee room. It's a rule that we have of the Senate. So senators who, though, are listening online will not be able to answer any questions or vote or participate in committee other than listening. Yes, Senator Baumgardner.
Thank you, Madam Chair. I really don't see this as a friendly amendment. And I know that since last year, when the Senate did pass out a similar but different constitutional amendment, we've had nearly a year's time since that did not pass on the House side. And I know that the proponents that not only testified last week, but also that worked on this piece of language, they have spent now nearly 2 years working on language. And, you know, it wasn't just in a vacuum. They allowed legislators, community leaders, members of their organization to participate in that process, but they also used data. And if we look at what has happened with regard to folks participating, Kansans participating in elections, we know that the off-election years, so those years, odd number years, have a low turnout. So even the general election of November 2019 only had an 18% turnout, whereas in our primary election of August 20, we had 34%. So we know that we have more Kansans participating on even number years. And we also know from testimony that this was the ask of the proponents. This was the ask of the organizations that are wanting to educate Kansans on what it is that the Supreme Court took action on, what it is that this constitutional amendment really would do for Kansans. You know, it's interesting, in listening to testimony last week, we had opponents repeatedly say that this constitutional amendment would ban abortion in Kansas. We had testimony that said when a similar amendment was passed in the state of Tennessee, that the legislature then took action to ban all abortions. just wasn't true. Just isn't true. So it will take some time with regard to messaging. And the fact of the matter is, several of the pieces of legislation that have been passed by the Kansas House and Senate, both sides of the aisle, those have been enjoined by the courts. Not struck down, but enjoined. And so this is the opportunity to educate Kansans as to what is and isn't in our Constitution, and what it is here in the 21st century they want their Constitution to represent. That is going to be an educational curve. And quite frankly, I think that it is, for no other reason, since there was that opportunity to discuss the date, I feel it is incumbent that we honor what was submitted to us, because as the carrier of this amendment has even indicated, there was not opposition to this date. I feel that it is taken to be true that the proponents support this date. That's why they were proponents, not opponents, for what we have before us in SCR 1602. So I am in opposition of this amendment. Thank you, Madam Chair.
Thank you, Senator Baumgardner. Other questions or comments from the committee? Seeing none, is there a motion or further debate? Is there a second? Seeing no second, the motion fails. Is there any other committee questions or comments on SCR 1602? Seeing none, is there a motion regarding SCR 1602? Yes, Senator Thompson.
Thank you, Madam Chair. I move to pass Senate concurrent resolutions number 1602 out favorably.
Thank you. Is there a second? Senator Baumgardner.
Madam Chair, I second the motion of Senator Thompson.
Is there debate on the motion? Seeing none, we'll vote on the motion then. The motion is to report favorably out of committee SCR 1602. All those in favor signify by stating aye. All those in favor signify by stating no.
No.
Senator Corson stated no.
And Haley, hello.
Senator
Hello.
Pyle indicates he passes, and Senator Haley, to be voting on the motion, you've got to be physically present in the committee hearing room. So
That was not my
the
understanding,
motion
but thank you.
passes. That will then conclude our work on SCR 1602. Thank you, committee. Before we move on to the confirmation hearing today, I wanted to make a request for any bill introductions. Do we have any bill introductions for the committee today? All right, seeing none. We will then proceed to the next order of business on our agenda, which is the confirmation hearing on Amy Klein. And I just wanted to set out a minute the logistics of how we're going to run the confirmation hearing. It's 10:50 right now, and committee proceeds to noon if we need it. We will try to wrap up a few minutes early. There's another committee meeting in a different committee that begins at noon today, where we've got some committee members that need to get to that. So we'll try to wrap up in an hour at 11:50. So that gives us 60 minutes. And I want to divide the time for questions evenly amongst the committee members who are present today. And we will do that once we have the opening statement from Ms. Klein. And we will do that then, we'll go alphabetically in order by committee members' names. So with that, we're going to open the confirmation hearing. The business before the committee is now the consideration of the appointment by Governor Kelly of Amy Klein as a judge of the Kansas Court of Appeals to serve subject to retention elections as set forth in statute, succeeding the Honorable Joseph Perrin, Jr. A little bit of history, KSA 20-3020 provides that any vacancy on the Court of Appeals is filled by appointment of the governor with the consent of the Senate. The clerk of the Supreme Court is required to give notice to the governor of any vacancy, and the governor accepts applications for the appointment and submits an appointee to the Senate for confirmation. To be qualified for appointment, the person shall have been regularly admitted to practice law in the state of Kansas and engaged in the active and continuous practice of law as a lawyer, judge of a court of record, or any court in this state, full-time teacher of law in an accredited law school, or any combination thereof for a period of at least 10 years prior to the date of appointment. Since KSA 20-3020 became effective in 2013, the appointment and consent procedure has been used 5 times, and the Senate Committee on Judiciary has held 4 hearings on appointees. Recognizing the importance of precedents in such historic matters, the committee will conduct this hearing as I've outlined and relatively similar to the manner as the prior hearings. So with that, I'm going to go ahead and allot 5 minutes for an invitation for Ms. Klein to make any opening statement or remarks that she may have prepared for today. And then that will leave 5 minutes for each of our committee members who are present, and then additional time for follow-up questions by any committee members. So thank you for joining us here in person in committee. Ms. Klein, welcome to committee. You may take the podium, and I'd invite you to make any opening statement or remarks you may have prepared for today. Committee, you have the confirmation packet in front of you, which includes letters and other documents for your review. Thank you. Welcome to committee. Please introduce yourself and give your opening statement. Sure, and make sure your button is pushed and your blue light is on. Thank you.
Thank you, Chairwoman Warren. Amy Klein. And thank you, Chairwoman Warren, and all the members of the committee. I appreciate the opportunity to appear before you today. And I thank you for the time that you've taken out of your personal and professional lives to meet with me since my nomination. I hope that each of those job interviews provided you with some insight into my background and experience, and they certainly provided me with a window into the commitment that each of you and your fellow senators have to serving Kansas. I appreciate the courtesy that everyone showed me in these meetings, as well as your diligence in handling your legislative duties. As you may know by now, I'm from Valley Center, which is a small town north of Wichita. My children and all my nieces and nephews attend the same schools where my siblings and I graduated. I'm blessed to come from a large, supportive family. Whether it's Scholars Bowl, music programs, or any number of sports, my family shows up to cheer each other on. From my sister providing daycare to my children, to my parents taking them to practice when the court appearance runs long, to my husband learning to cook vegetables for dinner when I'm out of town for work, they have all pitched in to help earn the nomination that led me here today, just as much as I've done anything to earn it. And since I know they're listening at home, I want them and you to know that I wouldn't be here today without their support, and I am ever grateful for it. As my family will tell you, I have long been captivated by civics and the law. I participated in student congress and debate in high school, and I also debated in college. Then I went back to coach debate at my old high school with my old high school debate coach, and she's the one who inspired me to become a lawyer. After I graduated from Wichita State, I attended law school at the University of Kansas. While at KU, I worked at the legal aid clinic, representing indigent clients in a variety of matters, including criminal, juvenile, and family law. That experience had a profound impact on me, which is why I became and have remained active in Kansas Legal Services, serving on their local and statewide boards and regularly providing pro bono legal representation. That legal aid experience also inspired me to serve on the Sedgwick County Criminal Appointments Panel after I graduated from law school. I have a deep and abiding belief in equal access to our justice system, and so I've tried to do my part throughout my career to help open the doors of the courthouse to everyone, no matter their means or the manners in which they're involved. I practice law for more than 20 years now, and I've always enjoyed variety in my work. Throughout my career, I've consistently sought out cases where I can develop new expertise and insight into how the law affects people's lives. I love that often in my practice, I have weeks where one day I'm taking depositions in a construction case, and the next I'm before the Corporation Commission in an oil and gas or utility hearing, and then the following week I'm working on an employment matter. In fact, the variety of matters that comes before the Kansas Court of Appeals is one of the reasons that I sought the position. Some states have specialized appellate courts that only hear criminal or civil cases, but I appreciate that ours hears cases from all types of matters, including administrative appeals, from matters before the Corporation Commission and the Department of Labor. And I've enjoyed my own administrative law experience, and I think that my experience with those unique rules and procedures would be an asset to the court. I think my diverse client background would also help me serve in this position. I've represented both plaintiffs and defendants, both individuals and businesses, because I believe that balanced perspective on the law is important. I've also appeared in courthouses all across Kansas, from Scott City to Kansas City, from Medicine Lodge to Manhattan, and I believe that geographic diversity in my practice would provide valuable insight to the Court of Appeals. I also have a blue-collar background, which I'm proud of. My parents instilled a strong work ethic in all four of us kids, and I think that work ethic would be valuable to our court. Our Court of Appeals handles more cases than any other court in Kansas, from all over the state and in every area of the law. I think my background and diverse experience would allow me to step right in and hit the ground running. If I'm confirmed, I pledge to approach each case with an open mind and to render opinions based on the law, rather than any personal or political bias. I pledge to respect the separation of powers in our government and to faithfully support and uphold both the U.S. and the Kansas constitutions. And I pledge to apply the laws that you enact impartially and equally to all litigants. I would be honored if you'd recommend that my nomination to the Kansas Court of Appeals be confirmed, and I'm happy to answer any questions that you have. Thank you.
Thank you, Ms. Klein. In alphabetical order then, if there are any questions, we will start with Senator Baumgardner.
Thank you very much, Madam Chair. Thank you so much for being with us today. I have to say that when I reviewed your packet, one of the things that did impress me was not only the depth of your experience, but particularly the breadth, because we know that for an appeals court judge, there is going to be quite a variety of cases which you will be called upon to address. And so I think that's particularly important. And so thank you so much, not only for submitting your application for this position, but for doing so when you felt you were ready for this next and very different step. My question has to do with your guiding judicial principles. We know that when a case goes up to the appeals court, it's because questions aren't immediately settled in the lower court. So what are your guiding judicial principles?
Thank you, Senator Amy Klein, in response to your question. Well, certainly the Court of Appeals, the matters that they decide are based on the record. And so you look at the record of what happened in the district court, the arguments that were raised, and the legal issues that are involved. And you look at the law that applies to the case. Because while the Court of Appeals gives a lot of deference to the district court in terms of making decisions on fact questions, there is no deference on the legal questions. The law is what controls the decision. And so that's what I would look to first and foremost to determine what's the statute that's at issue, what's the legal principles that are involved that would guide the decision.
Chair, I just have one other question.
Go ahead, you have 5 minutes total.
That question is, do you consider yourself a textualist or do you consider yourself an originalist when you are looking at what is the law?
Well, I believe there's a lot of similarities between those two philosophies, Senator. Oh, sorry, Amy Klein. I do believe that I'm an originalist in the fact when we interpret the Constitution, it should be interpreted in accordance to the original meaning of that language. But I think textualism is important as well, and that's really just a matter of looking to the words that were chosen. And that's really what the guiding force is in interpreting the laws that would come before me.
So if you saw the word shall rather than may, you would see that as a mandate?
I do think that there is a big difference between shall and may, and absolutely, you would interpret those words totally differently.
Thank you very much. Thank you, Madam Chair.
Thank you, Senator Baumgardner. Next, we have Senator Bowers.
Thank you, Madam Chair. Good morning, Amy. Nice to see you.
See you too.
Not really so many questions, just a couple comments I have for you. I'm glad you realize that's a variety of cases that will be before you, and with your experience in the past cases, how that can make you a well-rounded judge. So I appreciate you noticing that. I also appreciate your work with women on the different positions that you've held too as a lawyer in those associations. I guess I would like to know how you can continue to use, assuming you are confirmed, working with you in the future, and then how you consider working with the legislature. You would see having with us.
I certainly think that the courts are important ambassadors of justice right now. I speak a lot to elementary school groups on kind of the justice system at Law and Career Day. And I think it's important so that, the kids can see the judges are real people too, and just learn about what the job entails. And, I think lawyers are important ambassadors as well. And I appreciate, for example, one time I was asked to argue an appeal before an issue. The court hears panels once a year at different colleges, and they select certain cases and attorneys to argue in front of the college. And I think that's an important real-life civics lesson for the issue in that auditorium, to see the judges, have the case and hear the lawyers, and see kind of what appellate court judges do. I think that's a very important role that I would certainly like to continue to be that ambassador for the court. I think with the legislature, I've really enjoyed my meetings. I've tried to meet with as many senators as possible to prepare for today, to learn about what they want to see in a judge, and how the branches can work together. And so I would like to carry that forward and continue to listen to the concerns of the legislators and get to legislators and continue to know them as people, because I think that's important to remember.
Thank you, Madam Chair.
Thank you, Senator Bowers. Next, we have Senator Corson.
Thank you, Madam Chair. My question is, I'm impressed by the depth and breadth of your experience, and one of the questions because I see it's in your resume, but if you could maybe talk a little bit about it, is specifically your appellate experience, because I know that you have that experience in brief writing and appearing before the Court of Appeals. If you could just talk to the committee specifically about that part of your practice and your experience in that area.
Absolutely. It's been a regular part of my practice from graduation, a regular continuous part. I had 2 appeals just last year, and so I appeared before the Court of Appeals as well as the Supreme Court. And then I've also assisted some of my partners in writing briefs and in preparing for oral arguments at the firm that I'm a member of.
Thank you so much. I have no further questions.
Thank you, Senator Corson. Next, Senator Gossage.
Thank you for being here. You do have an impressive resume, and as Senator Baumgardner said, a breadth of experience. I have served on the Kansas Board of Indigent Defense Services, and so I remember that you have been on that list of providing pro bono services. And I'm curious how you feel that experience will help you on the court.
I think it's important to remember as a lawyer and as a judge that every matter that comes before you, whether it's a small house case that is maybe only worth $10,000, that $10,000 is still very valuable to the parties that are involved, and it doesn't matter the size of the case that comes before you. They're all equally important, and I think that experience helps keep you grounded in the law and in your perspective of the cases that come before you.
Thank you. That is all, Madam Chair.
Thank you, Senator Gossage. While alphabetically next would be Senator Haley. He's not physically present in the committee room, so that would bring next Senator Pyle.
Madam Chair, I just want to congratulate you, Amy, and thank you. I don't have any questions because I know that you would answer them very well. And so that's all I have to say, but congratulations.
Thank you, Senator Pyle. Senator Thompson.
Thank you, Madam Chair. I'll add to Senator Pyle's comments and congratulating you and also echo Senator Baumgardner's comments about the breadth and depth of your experience. I enjoyed our conversation the other day, and I think most all the questions I had were answered very well, and I don't have any additional questions for the conferee, Madam Chair.
Thank you, Senator.
Thank you, Senator Thompson. Senator Wilborn.
Thank you, Madam Chairman, and Ms. Klein, thank you for being here and jumping all the hurdles with an election year and COVID, and you surely made the rounds. In our visits, you talked about how you had visited with a number of the appeals court judges, and many of them had certain areas of expertise. Could you judge yourself as to what piece of expertise you would bring to the court?
Thank you, Senator Amy Klein. My understanding is that the current court would particularly appreciate my background in oil and gas and natural resources, in administrative law, my appearance before the Corporation Commission, and also utilities work. A number of them expressed the fact that that would be something that would be an asset to the court.
Thank you. And if I may, Madam Chairman, thank you for being here again, and best of luck. Bye.
Thank you, Senator.
Thank you, Senator Wilborn. I have just a few questions, and like other committee members have said, congratulations on making it through the process and appearing in front of committee today. Thank you for coming to committee to answer our questions and to provide information about yourself. I enjoyed meeting with you prior to today and learned about your breadth of experience and your practice so far. We talked a little bit about your practice kind of throughout the state as a practicing attorney, and would you please tell the committee how your breadth of experience practicing in courts of law throughout the state of Kansas, what that would bring to the Court of Appeals?
Thank you, Senator Amy Klein. I think that gives important context to the cases that come to the court, because our appeals come from every county across the state. And I've appeared in several of those counties, almost all in fact. And sometimes I appear in the rural counties in front of a district judge in the same case in 2 or 3 different cities. And there's different local rules that some of those judicial districts have. And I think that gives an important context to the record, to how the record is created, and how the issues come up to the Court of Appeals and what issues are at play.
In your experience in practicing in, I guess, all counties in Kansas, do you find they're different but yet the same, and you could bring to bear your experience on each of those times you've practiced in those counties to the Court of Appeals?
Yes, Senator, I do. I mean, obviously the law is the same in every county, but I do think there's some nuances with particular districts and issues that come up where knowing those differences and knowing where to look for those differences would be valuable.
And particularly in creating kind of the record on appeal, some local rules are different than others, and you're familiar with the vast majority of those. Is that right?
Yes, Senator.
Well, thank you for appearing today. I don't have any further questions. I would just ask, are there any follow-up questions from any committee members that they would like to ask?
Madam Chair.
Do we have any
Madam Chair.
conferees here who have proponent testimony to offer?
Madam
Seeing
Chair.
none, I'll then ask for any conferees present who have any opponent testimony to offer. Seeing none, then I'll ask then, Ms. Klein, would you care to make any closing comments to the committee?
Just briefly, Senator, I want to thank everybody for the time and attention that you're giving to this important appointment. I watched several confirmation hearings on the federal level to prepare for today. And one comment that stood out to me was in Supreme Court Justice Gorsuch's confirmation hearing, he said a judge has one client, and that's the law. Right now, as a lawyer, I zealously represent my clients. I diligently search for evidence so I can present the most persuasive case. I push to keep cases moving so the parties aren't stuck in limbo longer than they have to be. And I thoroughly research the law so I can explain why it supports my client's position. And I want you to know that if you and your colleagues allow me to serve as an appellate judge, I will be just as zealous in representing the law and the integrity of the judicial system. I'll diligently review the case record to ensure the system didn't fail the litigants. I'll timely issue opinions so the parties can get closure. And I'll continue to thoroughly research the law so I can properly apply it to the facts of the case before me. I thank you for the time you've given me before today, and I appreciate you allowing me to come here and speak with you as well.
Thank you, Ms. Klein. I want to, you can go ahead and have a seat. We have a question, just a moment, from, I guess, IT. I appreciate that. The Senate rules are that to participate and ask questions in committee, you've got to be physically present in the room. So I want to bring to the attention of the committee, in your packet includes these things: a cover letter from Senator Suellentrop, a memo from Robert Gallimore of Kansas Legislative Research Department, an appointment letter from Governor Kelly, Senate confirmation information summary, a resume from Amy Fellows Klein, the governor's appointment questionnaire, confirmation oversight committee document, Kansas Governmental Ethics Committee statement of substantial interests form. Governor Kelly appoints Ann Klein to Kansas Court of Appeals plus supplement. A document from Arst and Arst, from Beasley Law, Glassman, Bird, and Powell, Avery M. Effelson, Union Rescue Mission, Colliers International, Franklin Law Office, Kansas Legal Services, 2 letters. Excuse me, that was the timer. Dina Hyson Bailey, Law Office of Carrie Levy, Reddick Langworthy, Todd Lewis, Friends of the Great Plains Nature Center Board of Directors, Dan Likens, Constangy, Brooks, Smith, and Profit, the University of Kansas School of Law, David H. Moses, Mark Murrell, Eunice Chewenian Peters, Graybill and Hazelwood, Washburn University School of Law, Triplet Wolf Garrettson, LLC, Minter and Pollock, Rabine Brothers Trial Lawyers, Line Medical, Inc., Robert J. Schmeiser, Joseph A. Schremer, Leon Karolitz, Oil and Gas Law Professor, Fulston, Attorneys at Law, John R. Vietz, Attorney at Law, Bever Dye, Warren M. Wilbert, Triplet Wolf Garrettson, LLC, and past presidents of Kansas Women Attorneys Association. With that, our work for today for this appointment was to review the appointment materials that I've read to you, and to hear from the appointee any other conferees, which there weren't any. The Senate has referred the appointment to our committee for consideration, so I anticipate on Thursday we will have committee discussion regarding the appointment and action on the appointment. With that, then, we will close the confirmation hearing on Amy Klein. And seeing no other action items on the agenda for today, the meeting is adjourned. Thank you.